Who gets to decide who gets to question the president? Today we're looking at a case brought by the Associated Press versus the Trump administration on who has access to the presidential pool of reporters. Now, one way of looking at it is, should the president himself be able to make these decisions? Who is his close cohort of reporters that he trusts? And is he allowed to throw some out that he might ideologically disagree with? Or should we entrust this rather to a cartel, if you will, of media operators to decide which among them are the most fit to make these decisions? Let's jump in and explore this in DuPont Circle in Washington, D.C. today. As it turns out, who may be and who is not allowed to be part of the White House press pool is a controversy that goes back quite some time in American history. And really the biggest kerfuffle about all this was with President Woodrow Wilson in 1913. He was tired of those evening newspapers. You know, evening newspapers, the term of the day. Essentially what you might think about as trash news or misinformation today, and he threatened to get rid of all news conferences and cut out the press entirely for everything with respect to the White House. So in 1914, the White House Correspondents Association is formed because the press is rightfully concerned about the role of press access to the president during this time. So they start to form this, and it's largely an informal working group between President Woodrow Wilson and up until about World War II in the 1950s. All of a sudden, technology is increasing. Our ability to travel and transport to other sides of the globe are much easier, and more of the press wants to be able to work hand in hand with the president to be able to cover important stories. So we start with a really informal structure of the White House Correspondents, and it becomes more formalized as we push forward. The Kennedy administration in the 1960s formalizes it further, and it gets cemented really by the time of the Nixon administration as a functional gatekeeper for access to the president. And some of the rules that they agree upon is you have to have an office in Washington, D.C. if you want to be part of the press pool who covers the president. You have to regularly cover him. And they have sort of a rotating pool of members who are in this group, and they decide who's going to be in the White House press corps every year. Well, as it turns out, it's largely big media who controls this, and that's going to cause a problem for the Correspondents Association as it develops and matures. Controversies. So the White House Correspondents Association has no shortage of them. They start to act as a functional gatekeeper to who gets to question the president. In the 1980s, C-SPAN, that government-funded network that is purportedly neutral and nonpartisan, finds that it itself can't have access to the presidential pool. And under a heavy pressure campaign over many years, it's finally allotted one slot and is able to be part of that. In the 1980s, another thing happens, and that is regional news starts to take on more importance, and regional news actors correctly complain, this is big media protecting big media. Why do we only see ABC, CBS being part of the press pool in their national outlets? So the small little upstart news organization is never going to be able to qualify and be recognized by big media to be able to be part of the press pool. Regional actors who are underfunded and traditionally don't have as much press clout are not going to be recognized as well. And so these issues start to percolate, and the White House Correspondents Association starts to rethink about its composition. Protecting large conglomerate corporate news interests can't be what the White House Correspondents Association is really about, and that really can't be the purveyor of who gets to make questions that are critical to how the president is performing his job. But that's the controversy the association found itself in. Now we get to the early 2000s and we start to see an online technological revolution in the news, and Huffington Post and Slate and others start to become more powerful actors, and they're up against legacy media that's struggling even to this day and still using its power and its clout to try to hold on to these legacy positions. So through a pressure campaign of their own, eventually smaller digital outposts are able to have at least small little slices and small availability to enter the press corps and to be able to ask questions of the president. Now, during the same time, in the early 2000s, we get a wide string of complaints that the White House Correspondents Association really disfavors conservative outlets. So the Washington Times and the National Review file complaints about, sure, we come to the table with a perspective, but we're fair reporters, we're good reporters. And why can't we ever have an ability to be in this pool and to be able to ask questions that are critical of a Democratic president in power? This campaign goes on for some time and it unsettles the very core of that association. Not just during the Obama administration, prior to that, during George W. Bush's administration, you saw complaints about ideological discrimination as well. New upstart digital news outlets, the Drudge Report, remember him? Or WorldNet Daily, said that they in no way would ever have access to the reporters pool. They would never get to do this sort of direct questioning. So pressure started mounting on the cartel about what sort of diversity of membership should look like for it. Now, it's not just President Trump, but President Obama had problems with the qualifications and credentials of who the correct reporters were that he wanted. In fact, this is a very regular issue that comes up for presidents. During Obama's presidency, he claimed that Fox News was not a legitimate news organization, and he wanted to bar their access to the White House, bar their access to the press pool. Now, it was with some strange coincidence, other mainstream media actually stood up for Fox News and declared that a violation of press rights. And the Obama presidency slowly and gradually, thankfully, backed away from that approach. But it was also Obama who decided that we couldn't trust photographers, independent photographers, to be taking pictures of our president and of the presidential grounds, probably because of some embarrassing and unflattering shots from time to time. And so he moved to have a rule that the press could only use photographs from the official White House photographer. And now this caused quite the outcry, as you can imagine. Imagine if you could only get the news through one trusted source from the government or one official spokesperson. And this rule was gradually loosened and that approach was abandoned by Obama. But many presidents have struggled with how do you regulate and modulate news access, who's there, how they do it on White House grounds, sometimes for legitimate reasons, sometimes for some very petty or political ones. Now, Biden is no stranger to press corps controversies either. In 2023, President Biden issued a revised set of rules and regulations about who's in and who's out, and it led to over 400 reporters being de-credentialed, losing their ability to access the Oval Office and be able to enter into the press corps. Now, there was one particular reporter, Simone Ateba from News Today Africa, who was very upset about this. He happened to be a very energetic and loud reporter who had very contentious questions for the president, and he demanded that he be called on more frequently. It wasn't just whether he was in or out, that was an issue, But the thrust of what he was concerned about was that he needed more attention, that the president should call on him more frequently. So he brought a lawsuit to adjudicate this under the First Amendment. Now you can imagine that puts the situation in a rather difficult scenario. Is there a First Amendment right that the president has to ask a certain amount of questions to a press correspondent? Of course, the answer to that's no. That's something that we can't adjudicate in any easy sense, and that case was dismissed on its face. Now we go back to the first Trump administration, and we deal with the famous blow-up between CNN and Acosta and Trump. And in that scenario, Trump had been tired of certain questions and what he perceived as belligerence from Acosta, and he immediately revoked his press pass and ability to be part of that team. And this went before Judge Kelly in the U.S. District Court for the District of Columbia. Now I want to note, Judge Kelly is a Trump appointee. He ruled in favor of CNN, of Acosta. So Judge Kelly ruled under the Fifth Amendment, that's protection of property. So a press pass is a piece of property that gains you access, and if you've been given that by the government, then before it can be taken away, government has to follow certain rules, give advance notice, allow you to challenge it. Judge Kelly did not touch on the First Amendment issues that were present in the case, and CNN dropped the suit and Acosta was allowed back in. So that leaves us all in a sort of complicated scenario where we have a lot of presidents who get upset over petty reasons, revoke and pull passes. We have a cartel who's largely in control of this process in the background. And we're present today now with the Associated Press challenge. We're going to go over to the United States District Court for the District of Columbia and talk about that for a moment. So today we're in D.C., and right now we're in front of the D.C. District Court. It's one of the most important district courts in America. We just got done with a little business here. This is where Hoffa was tried. This is where a number of the big cases, Pentagon Papers, a variety of military tribunals, important cases that define civil liberties and constitutional liberties in America, all happened right here. And just recently, we had the Associated Press case against the Trump administration. It was heard by Judge McFadden, who, by the way, is a Trump appointee. And the issue there was that the Trump administration revoked Oval Office access by the AP because the AP had said, we are not going to follow the nomenclature the Trump administration has set out about the Gulf of America. We're going to call it the Gulf of Mexico. As for renaming anything within the country, and we can think about Mount Denali versus Mount McKinley, we'll go with the new naming. But if it touches an international border, we're not going to follow the Trump administration. Well, this caused some ire for the administration. It said until you revoke that change to your style book, you're not allowed to come in the Oval Office. And a First Amendment suit was brought. They sought a temporary restraining order, which you remember before we've talked about different procedural phases of cases. A preliminary injunction is an emergency sort of motion. A TRO, temporary restraining order, is an even more emergency, even more speedy process. They're disfavored by courts. You have to show a high level of injury and a high level of need for immediate relief. Judge McFadden, a Trump appointee, said no, the Associated Press couldn't show that here, that there was no immediate First Amendment injury. So why might that be? Well, it's one thing in the First Amendment realm to be able to say that we're going to go out and be able to report and record and talk about the news. But it's a wholly different thing to be able to say, I have the right to be able to access a particular place in the White House or to follow the president around and be able to report about him. Only so many people are able to do that. It's a limited number of seats, limited number of spaces. So it didn't seem like, if you're Johnny Jones and you're sitting in Omaha, Nebraska, you're a newspaper reporter for your local high school club, you don't have a right to be able to fly to D.C. and be able to get a seat right there. Why should someone from the Associated Press have that too? Oh, and by the way, the rules here, as we've sort of been exploring through this video, are set by the White House Correspondents Association. That's a private trade association. I think of it as a cartel, big media, guarding big media. And why should the President of the United States have to follow the rules that a private club set up? That seems kind of strange. Now, there could be a problem with what we call viewpoint discrimination if indeed President Trump has singled out the Associated Press and thinks that ideologically they're opposed to him, so he's going to limit their ability to do something that they were able to do before, and that's access to the Oval Office. But there was no immediate showing of that by the Associated Press. So if the Associated Press pushes the case, it will go to trial and they'll examine that. Now, the Trump administration has lots of good reasons to be able to explain and say it wasn't viewpoint based. They can say, look, we want press outlets honoring the standard verbiage and titles that we use. And if you're not going to do that, just whether you're Fox News or whether you're MSNBC, that's a precondition to be able to interact and be able to follow the president around. You're not allowed in the Oval Access because of that. But maybe they find something else, but maybe they find something more damning, right? They're going through a full trial and that Trump really didn't like these individuals and was trying to punish them. Then maybe you get to a First Amendment injury. But for right now, nothing. And we're going to explore, I think, a little more in depth some of the nuances of exactly what the cartel was doing. So while it's easy to get upset about what some people call big bad orange man, it's a little harder to understand what a cartel is doing. And that's where I want your attention and what we're going to focus on today. So we're left in this kind of unsettling circumstance. We've got over 75 years of a private cartel that protects big media, largely determining the meta rules about who's going to be in the White House press pool. We have occasional flare-ups of different presidents who get upset about issues, petty or political, and kick a reporter out here and there. Largely, the courts are very deferential to that. Not always, as we saw in the Acosta circumstance with Trump. And that leads us to today. Now, in the Associated Press challenges, we noted that they've failed, at least immediately, for being able to show a First Amendment violation. We'll see if the case matures into something broader and bigger and delves into the intent of really what the White House was doing when it placed this limit on Associated Press. But we can think about maybe 3 different scenarios where presidents might act and then think about what the First Amendment consequences would be. And so the easiest of these, and this is like going through law school and working through hypotheticals, which is helpful for understanding the law. In the first scenario, let's imagine Trump or Obama, whoever you like the least, is worried about the press and says that they're going to kick a particular member of the press out of the White House press pool. And not only that they're going to ban them from reporting about the president because they did some act. They renamed the Gulf of Mexico, or they reported negatively about the First Lady. That would clearly be a violation under the First Amendment. So imagine that a president issues a rule where only reporters who engage in accurate reporting are allowed to access the White House grounds. Well, then that opens up a challenge on viewpoint discrimination, examining exactly what a president means by accurate reporting. If they're using neutral standards that apply to everyone and they seem understandable, they probably get away with it. If it's secret code words for only allowing conservatives in when you're a Republican president or only allowing liberals in when you're a Democratic president, well, then you probably don't get away with that sort of a standard. Or here's a third. Imagine Obama or Trump says, we're tired of hostile news reporters. You're disrupting White House briefings. You're always bothering me on Air Force One. We don't want any of this. And we're not going to ban you, but we're going to put you in the last chairs, the last seats, the least selective areas for the press pool. Is that a First Amendment violation? Is there a First Amendment right to have a front and center seat? Is there a First Amendment right to have the best seat, the best access? No, of course not. That would be absurd. So you can see why many of these fail. And that's because we have a unique situation where access to the President of the United States is a very exclusive, limited and special thing. In First Amendment parlance, we would call this a non-public forum where government has a high level of power to be able to enact what we would call content-neutral regulations. So long as you're not trying to kick the Republicans out or kick the Democrats out, and you have a valid basis for your restrictions, you have a high level of authority to do so. We can see this in the Supreme Court's jurisprudence in First Amendment cases, like Perry versus the School Education Association, where the court examined whether school unions had a right to be able to access the boxes, the mailboxes of teachers, and whether by depriving them of an unfettered right, almost an absolute right, whether that was a First Amendment violation. And again, the court looks at this as a unique situation. There's only so much room in these mail slots. There's only so much availability to do so, and not every group can have access to it. So long as you're not discriminating on an actual viewpoint, we're going to allow heavy-handed rules from the government. And there's a whole slew of cases, we'll drop some of them below, that hold for a similar proposition. I think you'll see more of this sort of case law developing around White House press corps scenarios, and I think that'll be the operational framework that's best employed here. So I think the question that we're left with is, what's the best situation out of all of this? The news stories that you're being bombarded with in America is largely that President Trump is set out to destroy democracy and the First Amendment because he's kicked the Associated Press out of the press pool as if this was an absolute First Amendment right. And it bothers me that there's never any discussion that for over 75 years, a cartel of big media in America has had a stranglehold on this. It's developed its own rules. And the difference between someone like President Trump and a sophisticated media cartel is that President Trump acts in sort of loud, easily detectable ways, whereas a media cartel can operate for decades with a smile on their face and with PR agents, and they can gloss over this and make everyone feel like they're sharing and participating in a shared democracy when they're really manipulating behind the scenes that ABC is allowing one of NBC's guys in, and NBC is allowing one of ABC's guys in. And we're never going to let the upstart come in. We're never going to allow the challengers to come in, because that's going to disrupt the market share. It's also going to disrupt what I think to be a fair or aggressive way to challenge those who are in power. And I don't think that's any way of going about it. So I wish, in terms of American media coverage of this issue, that there was a little more balanced perspective of asking the question, do you want a president to have this power, which can be good or bad? You can use it in petty ways to strike down ideological opponents. Or do you want a cartel to be kind of floating in the background, making shadowy decisions, pushing people in and out of the pool? For me, I value transparency. I'd rather have clear rules that are set by the White House. I'd rather have cartels largely removed from this process. That's my own personal perspective, and I'll say it's at odds with some ways that we govern similar issues in America. We can think about the Presidential Commission for Debates. That's a private set of actors who get to decide how the debates are going to occur for presidential candidates, who gets to participate. Gary Johnson brought a lawsuit against them. I thought it was a pretty strong one before, indicating that by setting the threshold too high for independent candidates, you're basically creating a homogenized environment where you're only going to get a two-party system that's ever talking to the American public. That drowns out real debate, real reform, and new ideas. But that idea failed. So we sometimes see these pairings of cartels or private entities along with government to make important decisions about our democracy. I would rather we have clear rules, transparent rules, where the public can witness how government's acting, and they can decide, was President Trump correct in his assessment about the Associated Press? Do we like that? Do we not like that? Was President Obama right to call the Fox News organization not a legitimate news source? And to allow the political process to follow, but not to cede this power into the hands of a cartel. We'll stay tuned and observe the case in the U.S. District Court as to how this proceeds, and move on to other topics involving controversies with the Trump administration very soon.